Oh yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. Just want you to know we did something a bit unusual this morning. We just decided we'd pick a time to start court as opposed to when we normally do. No, actually, I'm kidding about that. We were just trying to make it a little bit more convenient for everybody since some of our cases had fallen away. We'll take just a few minutes and talk about our procedure, and then we'll call the first case. First of all, I know I'm dealing with experienced practitioners, but I always like to remind everyone each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to request any rebuttal time, you may do so after you've introduced yourself, but before you've begun your argument requesting that from the court. You may reserve up to 5 minutes of rebuttal time. Obviously, the appellee gets no rebuttal time. Our lighting system is meant to benefit the attorneys and the parties. And our lighting system is on the podium. Once you begin your argument, a green light will come on. So long as the light's green, you've got plenty of time. Once the light turns yellow, you're running out of time, and once the light turns red, you're out of time. And we ask that you please respect those time constraints. Something that's very important, and I can't emphasize it enough, is that these oral arguments are being live streamed. What that means at its most basic limit is this: whatever you say is going out there. So think about what you're going to say before you say it, because we can't take it back because it's going out there the minute you say it. So just keep that in mind once we begin those arguments. Ms. Angie, anything we need to take up?
No, Your Honor.
All right. Let me introduce our panel, and then we'll call the first case. To my right is Judge Karma McGee from Savannah. To my left, Judge Jeffrey Usman from Nashville. I'm Steve Stafford from Dyersburg, and we will be your panel this morning. Ms. Angie, you may call the first case, please.
Hope Federal Credit Union versus Jennifer Griffin versus Allstate Corporation et al.
Good morning, Your Honors.
Good morning.
I'm Drayton Berkeley for the appellee, Jennifer Griffin. I'd like to reserve 5 minutes for rebuttal.
All right, sir. 5 minutes. You may proceed.
Thank you, Your Honor. May it please the court, this is a case that arises out of a foreclosure that morphed into an insurance claim. We had a foreclosure that started, Ms. Jennifer Griffin owned a home in Chimney Rock in Shelby County, Tennessee. It was insured by Allstate. The mortgagee was Hope Federal Credit Union. Hope Federal Credit Union foreclosed on the property pursuant to the power of sale contained in a deed of trust in early 2019. Now, the effect of the foreclosure pursuant to a power of sale is governed by the deed of trust, which states that paragraph 22, it's page 349 of the record, which states, if the property is sold pursuant to this section 22, borrower, which is Ms. Jennifer Griffin, or any person holding possession of property through the borrower shall immediately surrender possession of property to the purchaser at the sale, period. If possession is not surrendered, borrower or such person shall be a tenant at will of the purchaser. Now that becomes extremely important when we talk about the additional living expenses in this case.
There had been no eviction here, right? And that she had not actually been evicted, she hadn't been ordered removed, there had been a foreclosure, but under your argument, essentially she's a tenant at will.
Well, she was evicted later on.
But at the time that the damage occurred here. She was not improper, you're saying a tenant will, she hadn't been evicted from the property at that time?
Correct. As of the fire occurred on May 8, 2019, the eviction had not occurred at that time.
Had any proceedings been filed at that time to have her removed, a detainer warrant or anything of that nature been filed against her at that time?
There was a bankruptcy proceeding, and I think they had ordered her to leave. She didn't. They filed a detainer warrant. I don't think the detainer warrant was filed until after the fire.
Okay, thank you.
What was the status of the bankruptcy,
As of May 8, 2019, Your Honor?
the time of the loss?
Date of the loss, I'm not certain if it had been dismissed or not at that time.
It was dismissed, though, at some point in time?
I believe so. Yeah, she didn't sustain the bankruptcy, no.
Okay. What type bankruptcy was it?
Chapter 13.
And I assume her plan had been confirmed. Had she made any payments through the plan?
That I don't know, Your Honor. I don't know if that's even part of the record, but I'm not certain if she made any payments in the plan. I can't answer that right here.
Okay. You may proceed.
Be that as it may, the detainer warrant, I believe, was filed sometime after May 18, 2019 to start the formal eviction process and to enforce Hope Federal Credit Union's rights to the property. We're not here about Hope Federal Credit Union today. We're here about Allstate and the coverages under the policy. The Allstate policy that was enforced in effect when the fire occurred were two. The foreclosure extinguished her right to the coverages under the structure. We don't really have a fight over that, but what we're concerned about is the additional living expenses and the contents coverages. Although the foreclosure extinguished her rights to the structure and the benefits that she would have received for damages to the structure, it did not extinguish her rights to her personal property, and it did not extinguish her rights to the alternative living expense or additional living expenses. Now, there's some cases in bankruptcy court that say a tenancy in will, which is what we're talking about, continues until there is a writ of possession issued to remove the tenants from the property, and I will cite those in I think it's called a supplemental citation here. So she was a tenant at will, and we've had federal litigation that indicates that when you're a tenant at will under in this situation, you also have rights that are governed by the Uniform Landlord and Tenant Act, but that's not an issue in this case. What it is an issue is, did she have an insurable interest in her contents on May 8th, 2019? And did she have an insurable interest in her living expenses on May 8th, 2019? Now, that's governed by state law under Butler. Now, what our courts have said and what this court has said is that an insurable interest is determined. It's not necessary to have legal interest or title to support an insurable interest under an insurance policy. An entity only has the benefit of the property's existence and suffer loss from its destruction. In this case, even though she didn't have legal title to the property, she stayed there. She had possession of it until she was divested by writ of possession. Therefore, she had a legal interest or right to her alternative living expenses until she was divested by writ of possession. Same thing with regards to her content. She had a legal interest in her property.
Counsel, with regard to the personal property, how do we square here the earlier filing in bankruptcy where she only has $900 worth of stuff, and then all of a sudden she has $1 million worth of stuff? I mean, that's a pretty dramatic transformation in terms of the amount of personal items she had in this residence.
That gets us to the second part of the argument that we were going to address a little later. The issue there is she followed the advice of counsel in deciding what to put on her bankruptcy schedules. She filed a declaration that stated, I followed the advice of the bankruptcy counsel. They pulled the stuff from the credit report. That's what we put on the bankruptcy schedules. I signed it based on their advice.
Isn't she responsible though? I mean, she's signing under oath in that filing. Isn't she responsible for that, for what she's telling the bankruptcy court, that she only has $900 worth of personal property?
She filed that oath on August 2018, and now the fire happened in May of 2019. So there's a massive gap. There's a gap in time where we think she acquired some more property.
My understanding of some of the property filings that relates to items that were claimed to have been in her possession for more than a year. So even that time period doesn't account for the year at least, doesn't it? I mean, isn't that already off the table in terms of inconsistency? If she said I had the item for a year, let's say electronics item for more than a year, and she says in her bankruptcy filing 9 months earlier, I own no electronics, and don't we have an estoppel problem there?
I would agree as to that item, yes. There's no way around that, but that's not all the items she's claiming. And that's why we're getting at the standard for a motion for summary judgment. We think that this is a matter that should have been tried because we have the issue of what is an insurable interest. We think that may be, and when we get to estoppel and whether there was a material misrepresentation on her proof of loss, I think those are questions that would properly have been put to a jury as to whether some things on her proof of loss should be excluded entirely, some things should not.
What about the rule of cancellation?
I don't think there was a deposition taken in this case. I think there was an EUO.
Now, you misunderstood what I said. What about the rule of cancellation? In other words, you've got a sworn statement where she says, this is what I have. Then you have a sworn statement that says, this is what I have. They're inconsistent and can't be reconciled. Consequently, there's a rule of law, the rule of cancellation, that could be applicable here. So how does that apply?
The rule of cancellation, as the court explained it, is there's one statement that says one thing on 2018 and another statement that says another thing in 2020 or later. I think that would have to be, it would have to be delineated as to which items that may apply to specifically. I don't think there can be such a broad application of that to say this is completely out because we said this earlier. Because like I said, there was some items that appear on the proof of loss that may not appear in the earlier bankruptcy schedules.
Was that delineated?
Not in the, I don't think it was delineated in the declaration. I'm not certain it was. I don't think it was delineated completely in the proof of loss schedule. There was some items on the proof of loss that were not. I don't think would be covered by her earlier bankruptcy schedules because there was a gap in time.
And who bears the burden of that delineation?
On a summary judgment motion?
On asserting a claim. Once the issue is before the court of, she said this in her bankruptcy schedule, she said this in her proof of loss, they're inconsistent and can't be reconciled. So at that point in time, the rule of cancellation has a overlying applicable principle here, which basically, if I understand the rule correctly, says there is no evidence at that point in time because they cancel each other out, if it is applicable.
Who has the burden of that?
Who would have the burden of proof to come forward at that point in time to show that I own these things and this is what I lost?
Well, obviously, the plaintiff would be at trial.
Well, no, at summary judgment, that's where you find yourself, not at trial.
Okay, well, that would only apply to the personal property. Do the court want me to continue, or because I'm over my time?
That's okay. Thank you.
Yes, sir.
Good morning.
Good morning.
May it please the court, my name is Jonathan Stewart with Rainey Kaiser, Revere and Bell. I'm here on behalf of Allstate Vehicle and Property Insurance Company. This court should affirm the ruling of the trial court granting summary judgment on behalf of Allstate on the basis that additional living expense coverage under the policy of insurance is unavailable to Ms. Griffin because she lacked an insurable interest at the time of the fire in May 2019, and also that contents coverage is not available to Ms. Griffin on the basis that she made post-loss misrepresentations in violation of the policy of insurance and pursuant to the doctrine of judicial estoppel. As Mr. Berkeley, who I have appreciated working with in his professionalism, as he pointed out, the doctrine of insurable interest is broad under the law in Tennessee, but it's not without bounds.
Doesn't a tenancy at will fall within that broad scope?
A tenancy at will, if the tenant had lawful possession, would. In fact, there's case law that we've cited, a situation where husband and wife get divorced, and the wife asks the husband to stay in the property to take care of it. The court in that case said that the husband maintained an insurable interest. He had possession of the property. He wasn't the legal owner. The property had been given to the wife in the divorce proceedings.
Isn't she a tenant at will with an obligation to pay rent under the terms of how foreclosure is supposed to operate with regard to the provisions that we're looking at in this case?
I believe that the deed of trust says that she's either to surrender possession immediately if she defaults, or remain a tenant at will, which would require payment of the reasonable rental value of the property.
Isn't that the status that she was in at the time?
Your Honor, there was a case cited by the plaintiff, the FNMA versus Daniels case. In that case, there was a position that the court explained that although a tenant at will where the foreclosure proceedings have occurred, the purchaser at the foreclosure sale has constructive possession. And here, the foreclosure proceedings had occurred, the foreclosure was valid. Hope Federal Credit Union had legal title and the right of possession to the property in February 2019 before this fire occurred. Ms. Griffin at that point was, if anything, in possession of the property unlawfully. It's different than the cases where the court in this state have said that less than legal title can maintain an insurable interest. In those cases, at least as I've read them, where the possessor had less than legal title but was in possession and had an insurable interest, they were in lawful possession. And here, the trial court, in 2020 on summary judgment by Hope Federal Credit Union said, and that decision has not been appealed, said that the foreclosure proceedings in February 2019 were valid, that Hope had legal title, and under the FNMA versus Daniels case, had constructive possession, as I read that
But
case.
isn't the tenancy at will anticipating that it's occurring at the end of a foreclosure proceeding? I mean, what's the legal action that's occurred that's made this any different than what's provided for under the deed of trust, where she develops this status? Where has it seems to provide for it? I mean, whether it's a good thing or a bad thing to provide for it, it seems to provide for it. So what here invalidated that status and made it improper? I mean, if it allows her to hold over essentially as a tenant at will and she just has a rent obligation, where did that become invalidated?
Your Honor, and unfortunately, I thought I had the date with me. I do not. And so I am hesitant to say with certainty because I don't have that certainty. There was a detainer warrant that was filed for possession of the property. And my recollection, and this is off the top of my head without having the technical record in front of me, and I apologize, is that had occurred prior to, the writ of possession had occurred prior to this fire. It was part and parcel with
When
the
did you
foreclosure.
get the writ of possession?
I'm sorry, Your Honor.
Let's assume, for purposes of discussion, that the writ of possession or the legal action commenced in April of 2019, and the fire occurred in May of 2019. At what point did your client obtain legal possession by way of the action it filed?
Your Honor, my client, Allstate, never had possession, if I'm understanding
Okay, yeah, I'm sorry. Do you know when Hope obtained possession?
I do not, Your Honor. What I do know is that the trial court found that the detainer was proper, the foreclosure was proper, but that was not determined officially by the trial court until 2020 in granting Hope's motion for summary judgment.
But following up on Judge Usman's question, there was a holdover after the foreclosure. Is that accurate?
That's my understanding.
Okay. And at some point in time, the purchaser of the property took action to take legal possession of the property and to, for want of a better description, evict the appellant, correct?
That's correct.
Was that legal action actually concluded subsequent to the loss,
Your Honor,
the fire loss?
my understanding, and again, this is without having the technical record in front of me, and I am frustrated with myself a bit for not having the actual date, was that the detainer warrant was filed in General Sessions Court. That part was concluded prior to the fire, which would, in my understanding, would mean that Ms. Griffin, at the time of the fire, was not lawfully in possession of the property.
So it's your belief that a writ of possession had issued before the fire loss occurred?
That's, Your Honor, that's my recollection, but I very well could be wrong about that.
Was that action ever appealed?
Your Honor, the procedural history of this case is so hard to, I do not know. It's so hard to keep track of. This was removed to federal court at one point. If I recall correctly, was in the Sixth Circuit at one point. Allstate was brought in late to the game. And so much had happened that I was not living with and not familiar with. I do not know.
Well, let me ask you a general question then.
Sure.
Does it make a difference in your analysis of the insurable interest as to whether the legal process for the writ of possession had actually concluded and Hope Federal had obtained possession through some court decision prior to the loss occurring, or whether that occurred subsequent to the loss occurring?
Your Honor, under my analysis, the answer would be no. There's no case law in Tennessee that I'm aware of that's directly on point, and we've cited the court to an Alabama decision and a Georgia decision that are factually dissimilar in the sense that they involved lease agreements that were assigned down the road. They were not dealing with foreclosure proceedings per se. But from a policy perspective, allowing a holdover in a situation like this, the danger that I see would only encourage folks insuring property that they have no legal right to, no possessory right to. And at the time of this fire, the foreclosure sale had taken, this wasn't foreclosure proceedings beginning, the foreclosure sale had taken place. Hope had bid in at the foreclosure sale, was the owner of the property.
Is there anything preventing the insurer, though, from putting that into an insurance agreement that, property post foreclosure shall be uninsurable property? And is there anything barring them from providing for that?
I suppose not. There are provisions in most homeowners insurance policies, as is the case with this one, under the standard mortgage clause that creates a separate contract of insurance with the mortgagee. I suppose an insurer could explicitly state that. But the doctrine of insurable interest that exists in Tennessee says that if a party doesn't have any benefit by the existence of the structure or suffer any detriment by its destruction, then they don't have an insurable interest. So for instance, I can't take out a life insurance policy on someone that I don't know because I have no insurable interest.
Had the premium been paid on this policy?
It had, per the record, yes, Your Honor.
Okay. So the insurance company had accepted the premium. Okay.
That's correct.
The situation that we're discussing, situation where property is foreclosed and someone holds over, that's not a unique situation, is it?
Your Honor, I would assume not. I would assume foreclosures happen every day.
And I don't have any facts to back that up, but I would assume that someone holding over subsequent to a foreclosure is not anything unique. So I guess I'm struggling why this hasn't been resolved before.
Your Honor, that's a good question. I don't know the answer to why this hasn't come up before. However, I believe in a case like this, the holdover doesn't, we're talking about additional living expense coverage. Ms. Griffin had no, and the purpose of insurance coverage being to keep the insured in the position they were before the loss, would, under that coverage, would entitle her to a benefit that she didn't enjoy as a holdover here. She didn't have the legal right to be in the property.
But nobody had said she didn't have the legal right yet, did they?
Well, she was litigating that issue.
That's why we have courts.
We do, and the court here, in a decision that has not been appealed, said that in February 2019, she didn't have the right to be in the property. She didn't have the right to possess it. She didn't have legal right to it.
Well, I assume what you're saying is the foreclosure has never been challenged.
That's correct. Nor the writ of possession. That has not.
Would you agree that in general a tenancy at will would be an insurable interest? If taking foreclosure out of it, then
sure.
In general a tenancy at will could be an insurable interest.
If the tenant is in lawful possession, yes. And I think that's the distinction here from the cases that I've found, and the major distinction from the cases that I've found where less than legal title supported an insurable interest is that the person that had that insurable interest was in legal possession of the property, unlike here.
But we're also assuming that the writ of possession had been issued prior to the loss, correct?
I am operating under that assumption today, Your Honor.
If that is not the case, does that change your analysis?
I don't believe so, based on the FNMA versus Daniels case that says that once the purchaser at foreclosure purchases the property, they have constructive possession of the property at that point. And I'm about out of time. Unless the court has any other questions, to respect that time limit, I'll end here.
Appreciate your argument.
Thank you, Your Honor.
Thank you, Your Honor.
Yes, sir, I believe you got 5 minutes.
Yes, sir. To answer the court's question, the writ of possession had not been issued at the time of the loss. There was a detainer action. It was appealed to circuit court on a de novo review. The circuit court required Hope to do a double bond proceeding under, I forget what statutory language is, and that writ was not issued till sometime, fire happened in May. This was not until right around Labor Day sometime.
Is all this in the record?
I believe so, yes.
Okay.
Because that was, well, we paid for it because those were important, germane to our arguments, yes.
I mean, the filing supporting what you're saying is in the record.
Yes, I know the bond is in the record. I think the court issued an order.
The court, you mean the circuit court?
Circuit
or
court
the
issued.
Sessions court?
The circuit court issued an order for the writ of possession. And I think it was dated August 30th or 29th of 2019.
But all this was subsequent to the loss?
Yes. Otherwise, we wouldn't be talking about this. And we agree that the Tennessee will supports an insurable interest, as Judge Usman stated. And we think that the analysis is that an insurable interest is supported by Tennessee will, and therefore Ms. Griffin had an insurable interest in her contents and personal property. Now, the court brought up the cancellation rule. The appellee did not make that argument, but we understand the court can address that as an alternative basis in some parts of its opinion if it so desires to go in that direction. Now, if this were a trial case, we'd have a problem with that, but I'm not certain. I think the initial burden of proof is on the appellee or the defendant to negate an essential element of the case.
Well, let me give you another scenario.
All right, yes, sir.
And that scenario would be this. You're basing your claim on what your client filed with her proof of loss.
On our contents, yes, sir.
And then as adverse proof, the appellee has filed with the trial court her statement in the bankruptcy court.
Yes.
At that juncture, by assuming that I have a good understanding of this, which I may not, the cancellation rule would say you've got this statement, and they're addressing purportedly the same items, and consequently there is no proof.
I think that's a fair application of the rule of the statement of cancellation. It would operate the same way in depositions. I say X in one deposition, I say Y in a subsequent statement, they cancel each other out. So,
So what proof is before the court at that point in time?
well, the only proof that'll be before the court will be any other items that are outside X and Y. Now, we didn't delineate that in this case, is what the court's getting at.
The filing, there's 9 months here of separation between the two filings, right?
Say again now?
There are 9 months between the two filings in this case in terms of the bankruptcy and the lost items that are asserted, a 9-month period. Is that
Yeah, that's about right, Your Honor. Yes, sir.
And there's listings at different time intervals. This property I had for over a year, this one I had for more than 6 months. For the 6-month items, what do we do? I mean, 6 months to a year, 9 months. What do we do about the 6-month items that are in that interval between 6 and 12 months where, and maybe she had it for 10 months, maybe she had it for 8 months that she's reporting that she had it for. How are we supposed to look at the 6-month related items, the ones that she had for less than a year, but more than 6 months?
Well, I think those would be genuine issues of material fact for the trier of fact to decide whether they are covered by the policy or not, is how we look at that.
Has she represented, though, that it's 8 months as opposed to 10 months? And I think this may relate to Judge Stafford's question here in terms of if it's, she says I've had the item for more than 6 months, do I know, and less than 12, do I know she's telling is she telling the insurer that she's had it for 8 rather than 10? Or I just don't know? Is there no evidence on that? Just that it's between 6 and 12?
I think that's the only evidence we have. It was just an EEO take. It wasn't a subsequent deposition to nail that down. I think is what the court's getting at. If it goes back down, it may be what they want.
All right, sir, thank you. You've used your time.
Yes, sir. Thank you, Your Honor. It's always a pleasure.
We appreciate your argument. We will take this matter under advisement, review the record, and attempt to get you an opinion at the earliest possible time. Thank you. You may be excused. Thank you.